Hi, I'm Tracel Wilt, real estate agent here in Wilmington, North Carolina. Thanks so much for joining us today. I have my friend Gansmann here with Cranfill, Sumner, and Hartzog, attorneys at law. And we were talking in our last video about trusts. And I had some questions from clients that live in different states. They have a primary home, say in New York, and they're here buying a second home that eventually, or a vacation home that'll eventually become their second home. And one of the conversations we had was about how do you put things into trust and when does it go through probate depending on someone passing. So Kira has a couple more details that I'd asked her to share and talking about those clients.
So we work with a lot of clients who own property in 2 different states. And we always recommend trust for those kinds of clients. And here's the reason why. When they pass away, without a trust, those properties will be probated, and that means going through the court system of each respective state. So if you have clients in New York, the property in New York will go through probate in New York. And sometimes, as I understand it, probate can be expensive in other states. North Carolina doesn't have truly expensive probate costs, but those fees can add up quickly, up to $6,000 under North Carolina law. So that property here in North Carolina would also go through probate. And so you're looking at, it could be $6,000 alone in one state and even more in a different state. So a trust would resolve that. If you put both properties into trust, you again protect and control who gets that property, when they get that property, and how they get that property, but you're also avoiding probate in 2 different states, and it streamlines the process for your loved ones, brings you a lot of peace of mind.
A quick question, how long does probate usually last? Are we talking a couple days, a couple weeks? How long are assets tied up in probate?
Here in North Carolina, you'll have a 30 or a 90-day notice period to creditors. And so typically a probate is no shorter than 90 days, and that's a very efficient probate. Generally, probate can be wrapped up after that, but we have had probate last many years. And we still have a few probates ongoing from 5 years ago. And it's just various complications arise that require the estate to remain open.
So if someone had put that property in trust, it would have never gone into that process, so you would have saved yourself 90 days or a year is what you're saying.
Exactly, and the cost to administer the probate ongoing, which at that point could require legal fees.
So one of the other type of trust we talked about was an irrevocable trust. Can you explain in what situations that might be most appropriate for some of the people watching?
So we use irrevocable trust as part of our long-term care planning. And this is when people are looking at end-of-life planning, when perhaps they have a spouse who might need nursing home care and they'd like to preserve assets for the spouse who remains at home, or for individuals who are looking at long-term care planning and would like to leave a legacy gift for their family members. We use an irrevocable trust to achieve those goals, and it allows them to eventually qualify for Medicaid if that's what they need and they need a nursing home care. Conversely, if we're still looking at long-term planning but we don't have the benefit of 5 years, which is what we would like for Medicaid planning, we can use a deed process involving a 1% deed transfer, and that's something we can do in our office as well.
So I know we're limited on time and this is pretty detailed, but will you talk a little bit about the 1% deed transfer, and if someone's interested in that, what are some things they should come to you like prepared to discuss?
So that's a recommendation we'll make, but based on the assets that somebody has and the amount of time that we might have to pre-plan for any nursing home care or long-term care.
Okay.
So it's not always a good recommendation for everyone, but it is something we can do under the current laws of North Carolina. And that deed process comes into play where we would have the children, usually a child, but it could be anybody else, purchase a 1% interest in someone's property. And then that turns that property into a tenancy in common. Several weeks later, we'll do a second deed that turns that ownership from tenancy in common to a joint tenants with right of survivorship, so that ultimately, when the parent passes away, the children can inherit the home. There are some caveats, and those are things we would discuss with people, and some concerns. It's not a fit for everyone, but it's certainly a tool that we can use in certain circumstances.
Well, this is a very complex subject, and again, not something we can solve in 4 minutes on a video, but it's great information for someone to get started, as well as what I took away from this is you really have to plan. If you have assets, you have a home, you have family members that you're trying to leave that legacy for, and you want to be in control of where those assets go, you really need to plan. And Kara is someone that can help you walk through those steps and has a variety of tools that are available to help you do just that. So I will put Kara's contact information in the notes section below the video. Please feel free to reach out to her. She just is a wealth of knowledge. So thank you again for all of the information that you shared with everyone here. And if you need to reach me, I'm at 910-599-5422, and I'm happy to answer any real estate questions that you would have in conjunction with your estate planning. Thank you.